Okay, let's come to order. Clerk, call roll, please. Okay, this is the
You have a quorum, Mr. Chair.
thank you. This is the last meeting of Senate P&E this session. We haven't really taken, had a sign-up sheet before, but I see we have one today. So if you want to, Dawn, you're the first one. Delegate Adams, you're the first one on the list. If you want to go first, that's fine.
Mr. Chairman?
Senator McDougal.
Mr. Chairman, this was one Delegate Adams took it by last week so that we could look into some things, and we did. And so I want to thank her for the time, and when we looked at the statutes, the cross-references alleviate all the concerns that I have with the flexibility for there to be a lesser indication on a text message than on some other forms.
This was 1062. I remember it.
Yes, Mr. Chairman.
Do you have any problems with it anymore?
No.
Okay. Does everybody remember this bill?
Move report.
Okay. Got a motion to report and a second. Is there anybody in the audience that feels like they need to speak on this issue, on this bill 1062? All in favor, vote aye. Vote against, vote nay.
My friend.
12 ayes, your nays.
Thank you, Mr. Chair, members
Okay,
of
the
the committee.
bill reports. Thank you very much, ma'am. The next name on the list is Levine.
Should I take it by temporarily, I think, maybe till a few members get here? Why don't I do that?
You can do that if you like. That's fine. Delegate Van Valkenburg.
Thank you, Mr. Chair. So I have three bills. Two of them are related to the constitutional amendment on redistricting reform. Should we take those two up first?
Yes, and the constitutional amendment, you've got a ballot bill.
And the enabling legislation, which is similar to Senate Bill 203, which Senator Lucas carried.
Okay, and with respect to the ballot bill, it probably makes sense to put an enactment clause on there
Yep.
to require the constitutional amendment to pass, because this committee, the Senate has done what it can.
Yep.
It's in your body now.
Yep.
But does that make sense to put an enactment bill, at least, to put
Enactment clause.
enactment clause on this, on the bill, on the, Beck, can you get that done for us? Okay. Do I have a motion to do the enactment clause? Okay. And a second? All in favor of sticking the enactment clause on that Senate bill or House Bill 8 or 784, say aye. Okay.
Is that?
Now, this bill is identical to Senate Bill 236 with that one distinction, and it simply puts it involves the question for the referendum, puts the constitutional amendment on the bill. There are no other differences. Senate Bill 236. Does anybody have any questions for
Move report.
784.
Is there anybody that feels like they need to speak on 784? Okay, all in favor say aye, or vote aye on the electronic voting machine.
Eleven ayes, one nay.
Okay, 11 ayes, 1 nay. Bill's reported. And the other bill you've got that's related is House Bill 758.
Correct. And Mr. Chairman, members of the committee, 758, what we need to do, I think, is we need to conform it to Senate Bill 203 so we can kick this thing to conference for similar reasons. But we
Okay.
also need to, I think, fix a piece of the broader bill as well, which we're going to need to do in conference related to
Finance
timing.
wants all these bills. Okay, well, that last.
Oh, it needs to get right.
Yeah, that last
Right.
motion was to report and re-refer to finance. And if this one's going to go forward, it's going to have to have the same kind of motion. But a motion for the amendments, you've got to conform it basically to Senate Bill 203.
Right.
Okay. Is there a second?
Second.
Okay. The second for the conforming amendments, all in favor say aye.
Aye.
Okay, and were there other amendments you wanted for this bill?
Not for the meantime. No, I think we just need to kick it to conference. And
Okay.
Council can speak to that if you'd like.
House Bill 758, is there anybody in the audience that feels like they need to speak to this bill? Okay. Got a motion to report and refer. Are there other motions or other people on the committee that feel like they need to speak to this? If not, vote on the electronic voting machine. Okay. The bill goes to finance.
11 ayes, 2 nays.
And the other bill you've got is 761,
Yep.
which was a little curious to me, and you might want to describe that a little bit.
Yeah, for sure.
What it
Thank you,
does.
Mr. Chairman. Mr. Chairman, members of the committee, House Bill 761. I'll explain the bill, and then there's a substitute that is mostly technical changes. So I'll explain the bill, and then I'll hit what those changes are, and council is passing them out right now. Bill 761 is kind of a state version of the Voting Rights Act.
Well, hold on a second.
Okay.
There's a substitute. Okay, is there motion and a second to adopt the substitute? All in favor, say aye. Okay, the substitutes before you, that it's basically a recognition that certain parts of the Voting Rights Act were struck down, and this was an effort to put those in the code. Is that correct?
So 761 is a response to Shelby County in 2012. U.S. Supreme Court,
Okay.
right, declared that Section 4 of the Voting Rights Act was unconstitutional, and which essentially gutted Section 5, which was the pre-clearance sections of the Voting Rights Act. And there's been many attempts to revive that at the federal level, and they've all failed. This is an attempt to do it at the state level. And so, what we've seen since pre-clearance was gutted is we've seen a lot of backsliding on voting rights, both at the state and local levels. 85% of pre-clearance actions from 65 to 12 were local actions, were local pre-clearance. And so if you look through the bill, if you look through the substitute, because the substitute is essentially mostly the same as the regular bill, what you're looking at here is at the top line you've got definitions of what a covered jurisdiction is. And then you've got definition of what a covered practice is, what are covered practices under preclearance, all right? And then from there, you've got the actual process for it. Now, the Voting Rights Act is probably the most effective civil rights tool we've had for voting rights. After the Voting Rights Act was passed in 1965, the difference between black and white voter registration shrank in a decade from 30% to 8%. The 50% gap between black and white turnout was almost erased. And since Shelby County, we have seen backsliding. So, for instance, there were 1,688 polling closures in between 2012 and 2018 in covered states and localities. Georgia is a particularly kind of relevant example here. They've closed 8% of their polling places since Shelby County. Post-Shelby County, Section 5 jurisdictions, of which Virginia was one, have shut down 20% more polling stations than non-Section 5, non-covered states. They have 10% more people per polling location. And we've seen incidents just here in Virginia that would have, in the last election cycle, that would have been covered. So 2 examples. One is in Virginia Beach, there was a lot of coverage of the change of the registrar's office, which would have moved the absentee voting location a mile off the bus loop 2 months before the election cycle, right? Just 2 months before the voting, they would have changed that, if not for a local uproar, but that's the type of thing that would be covered. Also, Prince William County at the last second tried to change their absentee voting hours from, I believe, 5 hours to 2 to try to shrink it. That would be covered under this. And so if you look through the bill specifically, I would point you out to covered practice on line 21. This is of the substitute version that council just handed out.
Covered jurisdiction on line 18.
Yes.
Certainly that doesn't include the whole Commonwealth of Virginia.
Correct. Yeah, correct. So covered jurisdiction does not include the whole Commonwealth of Virginia.
You're only talking about localities that have 2 or more racial or ethnic groups, each constituting at least 20% of its voting age population.
Correct. And if you go to the last page on page 4, where it's Section E explains the process for how we find out what those localities are. Right, this is based off of best practices from national and state voting rights lawyers. That's where we got the covered jurisdiction from. Covered practice are the practices that are covered. So if you look through that, you can see things like voting precinct changes, boundaries to election districts or wards, things of that nature. If you go to Section B, B explains it. B is essentially modeled on the National Voting Rights Act. So if you're a locality that's covered and you make a change, you could choose to go to the Attorney General, or you could choose to go to the Circuit Court of the City of Richmond. Now that is one change that was made in this substitute. We previously had circuit courts, all right? But under advisement, we changed it to the Circuit Court of the City of Richmond. This is not a new thing. There's precedent for this. And so I want to make sure that that's clear. And that, let me see if I can find, sorry, give me 1 second. The Office of the Executive Secretary had no objection to this change because there's precedent for the Circuit Court for the City of Richmond covering unique cases. Okay, so Section B explains how that works, how you go to them. Sections C and D explain the process of how you would go through it and what the appeals process is. So if you're a locality, Section D explains if you think that, say, the Attorney General was wrong, how can you appeal this process? And so I guess
But an appeal for a locality would you revert back to paragraph B. It would have to be in the Circuit Court of the City of Richmond.
Correct. And the last thing I'll note before I'll let you ask questions is that most of the changes that were made in the substitute were definitional. So for instance, lines 12 through 17, lines 35 through 40, line 81 and 85 through 86, just kind of for clarity's sake, essentially. The two substantive changes, one I've already mentioned. One is you can appeal to, if you choose not to appeal to the Attorney General, you choose to go to the Circuit Court, you would go specifically to the Circuit Court of the City of Richmond. And then the second change, which is kind of where I'm going to end before you can ask, open it up for questions, I suppose, is lines 90 through 93. What we've done is we put a delayed enactment, two delayed enactments, right? Because this is a wonky year coming up, right? And we are making changes. One is a delayed enactment for the whole bill. And a delayed enactment would say that this is not going to become effective to July 1, 2021. The second delayed enactment is specifically to subsection B, which gets to district drawing, line drawing. You know, we are gonna have a census, we're gonna have new lines drawn, and so that particular section wouldn't go into effect. So for changes made to the boundaries of election districts or wards until July 1, 2022. And the effect of this is to make sure that there's time to implement it, there's time to implement it well. And so I think I'll stop there.
Okay, are there questions for Delegate Van Valkenburg?
Mr. Chairman.
Senator Reeves.
Delegate, if I can take you down to line 26 on the substitute, you have reduces by more than 5 percentage points. I think on the, at least my understanding is we've always stayed around 2% for the Voters' Rights Act. Why is it 5? Why does that give greater flexibility? Shouldn't it be tighter?
Supreme Court, 5 is the Supreme Court standard. That is,
Reduces by more than 5.
and
Mr.
what they
Chair,
allow.
I can
Correct.
answer that. Mr. Chair.
Senator McClellan.
Thank you, Mr. Chair. Under the jurisprudence under the Voting Rights Act by the Supreme Court, they have said that for a deviation that states may and localities may go up to 5. So this is just
Covering all of that.
putting in the event that the Voting Rights Act is gutted or not reauthorized or anything happens with the Voting Rights Act, that we put in code the standard of the Voting Rights Act as it is today.
Are there other questions?
Mr.
Delegate
Chair,
Senator Vogel.
I have a question.
Yeah.
This is a rather large departure for our localities, and I respect the fact that we have a delayed enactment. But I just am curious to know what our localities have to say
Well,
about this. Okay.
And that's fine, but Mr. Chairman, members, I would reject that premise because localities have been doing this since 1965. So it's not a large departure from what they have been doing.
So your argument basically is you're just requiring the same things here that were required under the Voting
Correct.
Rights Act.
Correct.
Okay. Senator Evan, you had a question?
No, I was just going to clarify that it is what was required. And, I mean, the Voting Rights Act, just to summarize this, if I got it right, was to see that no one was denied or abridged their right to vote on the account of the race or language minority group, and that we would pre-clear it with federal elections.
You're talking about the Federal Voting Rights Act? You would clear it either with the Attorney General or with the Court of Appeals in D.C. was the process that would happen under Section 5 of the 1965 Act as it was reauthorized.
And, Mr. Chairman, we're just moving that to the Attorney General of Virginia. Is that correct?
So we are implementing a state version of that in lieu of the fact. Now, I mean, I'll be the first one to say that the ideal world would be that the Federal Voting Rights Act would be redone, Section 4 and Section 5 would be redone at the federal level. But in light of the fact that that's not happening and that we are seeing backsliding since the Voting Rights Act was gutted in Shelby County, I think it's important as a state that we do our part to ensure, and we've seen local examples just in the last year, I think it's important that we do our part, whether it's intended or just has the effect of discriminating on race. I think we should want to prevent any of that. And so I think, this has been one of the most effective tools in voting rights that we've seen. It's unfortunate that it's gone at the federal level, and I think we should be a leader in protecting minority voting rights at the state level.
Thank you.
Okay, now comes the time when anybody who wants to speak for or against this legislation ought to come up and form a line.
Mr. Chair, members of the committee, Tram Nguyen with New Virginia Majority, we support this legislation. With the double delayed enactment, essentially what this bill will do is all of the voting changes that you all are passing this year, plus the redistricting, it'll essentially ask the Office of the Attorney General to look to see if there's any retrogression from that point forward, right? So any changes that covered localities make starting in 2021, it'll see if there's any retrogression and any disparate impact or potentially rolling back of impact on voting rights for minority populations. So we support the bill. Thank you.
Thank you.
Thank you, Mr. Chair, members of the committee. Anna Scholl with Progress Virginia. We also support the bill. We think it's an important measure to make sure that every eligible voter has the opportunity to make their voice heard with equal opportunity across our Commonwealth. Thank you.
Okay, thank you.
Good afternoon, Mr. Chairman and members of the committee. Katie Boyle with the Virginia Association of Counties. And I'd like to say we really appreciate the good intentions behind this bill, really appreciate the patron's been very generous with his time in talking with us about this. But respectfully, I think we just have to oppose this bill. I think it's fundamentally problematic that this bill does not apply to the state when the state has such a significant role in setting out the conduct of elections, whether through the General Assembly or through the State Board of Elections. I would just point out a couple of practical concerns. Appreciate that the applicability has been limited, but I would say applying this bill to jurisdictions that just merely are diverse seems a bit arbitrary. It seems to suggest that having a certain level of diversity would warrant special state scrutiny. I would also point out that changing the applicability from year to year, I think, could be somewhat problematic for jurisdictions not necessarily knowing whether they're covered from year to year, not necessarily because they would change their practices, but because they need to plan for the time for the review and for the legal costs that they may need to incur for jurisdictions that perhaps don't have in-house counsel and need to budget for this. So I do appreciate the delay that was added today. I think that would make things more workable, but we do have some concerns about the bill. So thank you.
Mr. Chairman, can I ask a question?
Senator Evan.
The Voting Rights Act at the federal level required only the states that had been judged to have been discriminatory in the past to get preclearance. Is that right?
That's my understanding, and that there was a coverage formula that was sort of based on a history of discrimination. There were provisions for bailing out. I think it was pretty stringent, but you had, I think, to document 10 years of no complaints and meet certain other criteria.
Yeah, and I would just note that the denial of right to vote or making it harder to vote for minority groups is the reason that there was a Voting Rights Act or is a Voting Rights Act, and that's why I'm assuming in the delegates' bill it's put out that way. That minority populations and counties with minority populations would receive special clearance.
That may be the thinking, yeah. Thank you.
Thank you, ma'am. Yes, ma'am.
Good afternoon, Mr. Chairman, members of the committee. I'm Jessica Ackerman with the Virginia Municipal League, and I'd just like to follow up on my colleagues' comments from the Virginia Association of Counties. One point that I'd like to speak to is with regard to the bailouts. There were approximately 50 localities throughout Virginia that prior to 2013 had qualified for the federal bailout list and were deemed to not have demonstrated any issues with any sort of racially oriented changes to their electoral boundaries, polling places, et cetera. But again, along with my colleague, I'm afraid we have to oppose this bill. Thank you.
Thank you. Okay. Delegate Van Valkenburg, do you want to finish it up? Or?
Yeah, I mean, I don't think it's arbitrary to say that the places that could possibly discriminate should be the places that are covered. If you're a locality that can't possibly discriminate, that it would make sense that they don't have to go through that process, right? So the reason it's not arbitrary at all, it's actually based on best standards according to national voting rights attorneys. As to that they would have to every year go through this process, I mean, I don't think that's really right. If you look at Section E, right? Well, you know, if you look at Section E, it's you know, what percentage of localities are going to have such a fluctuation in their population that they're going to possibly have two groups over 20. I think maybe this would apply to one or two localities. If it's the will of the body to change that to more years, so it's not every year, I don't think that that's a problem. But I think we also need to recognize that that's at tops one or two localities that might be in that fluctuation point, and they would know they're in that fluctuation point, right? Because they would know what their demographics are. So I don't think it's really like, hey, all of a sudden, you know, Wise County is like, we might or might not be there. I mean, I think they know their demographics and they know their population and they know if they're going to fit within that and they can prepare. So, you know.
Mr. Chair?
Senator Boysko.
So just a question. I love the concept of this. I think I love where you're going with it. I have a question.
Yep.
Are you using census data? How are you determining the demographic makeup of the community?
If you go to line 82, 81 and 82, it says each year no later than 6 months after the annual release of American Community Survey data. The Attorney General shall utilize such data to determine which counties and cities in the Commonwealth have a voting age population that contain two or more racial or ethnic groups constituting at least 20%. You know, and then if you go to the last line, agencies of the Commonwealth shall provide assistance to the AG as necessary.
Would the delegate be open for a reenactment clause rather than delayed by just 1 year?
How do you? How are you?
My concern is this. I mean, it's a new bill. We didn't see a Senate bill like this. It is the right thing, but you've got a delayed enactment already. And give us another year to think about it. If we require that it be reenacted next year.
Mr. Chair, just one other question, if I might, before we go further down.
Senator Eben.
Is there a representative of the AG's office here? May I ask Delegate von Valkenburg one more question?
Yeah.
Has the AG's office weighed in on this at all?
We've been working with them the whole time. And these last set of amendments are to help clarify for them. So the definitions, for instance, are definitions they asked for clarity's sake. The change for the circuit court was a change they asked for, so we made it because I think it made sense. The delayed enactment they asked for.
My thinking is if we replace 90 through 93 with a reenactment clause, that at least gets us forward to conference. We have a few more days to think about this. That might be a way to move the bill forward at this time.
Mr. Chairman?
Senator Spruill.
When you thought that if worked with the AG's office that had they want to do that, they would have said something by now? I'm just thinking of what you were trying to do, but he has been working with the AG's office, so I would have thought if they had that concern, they would have made those same comments you just got through talking
Well,
about.
I appreciate that, Senator Spruill, but the AG's office doesn't have any votes in this room.
Yes, sir, you're right.
If that is the Senate's will to help move this thing forward, if that's what it's going to take to get the votes, I mean, sure. I think this is an important bill. I think it's a needed bill. And so I want to make sure that it gets passed because I think it's going to help voters in Virginia.
Senator McClellan.
Mr. Chair, if a reenactment clause is what's needed to get this out of committee, that's one thing. But let's be very clear about why we have this bill. We have this bill because the pre-clearance section of the Voting Rights Act was overturned. And Congress has not acted to reinstate it, even though the Voting Rights Act reauthorizations every year until recently, every time it was up for reauthorization, it was reauthorized on a bipartisan vote, overwhelmingly. And yet right now, for reasons everyone can decide why for themselves, Congress has not acted. But the reason for the Voting Rights Act was, despite the 15th Amendment being put in place 150 years ago, laws were put in place in response when we came out of Reconstruction. Here in this state, in 1902, a new constitution was put in place to disenfranchise African American men who had been given the right to vote as a result of the 15th Amendment and the state constitution of 1868. And with the stroke of a new constitution, a whole race of people were disenfranchised. Through poll taxes, literacy tests, and all kinds of things that have happened at the state and the local level. And it wasn't until the Voting Rights Act of 1965 that said, if you have a history of voter discrimination on the basis of race, we're going to scrutinize the changes that you make to your voting laws to make sure they are not intended or in actual fact disenfranchise people on the basis of race. We have lost that protection. Now, every year that has gone by where we have not had the preclearance provision of the Voting Rights Act is a year that changes can be made that disenfranchise people of color, whether intentionally or not. Every year we delay is another year those changes can be made at the local level. We can't control what Congress does. We can't control what our localities do. And so, again, if we have to have a reenactment clause to get this out, but we are already delaying through 2 election cycles. And I think that we need to move this forward.
Well, Senator McClellan, I understand we're already delaying. I just want some more time to think about the precise provisions. I'm not opposed to the idea of this bill at all. I just want to make sure we get it right.
Yeah, I agree.
Senator Dees, Mr. Chairman.
Senator Spruill.
But some of us don't feel the way you feel. That's what you feel.
I understand that.
So I mean, but we got to get out now. So after all this time, you as chairperson, you know about the bill, you have read the bill, and we have had a couple years already passed by. So why would another year? Because you feel that way, but don't hold us up because you feel that way.
I'm not holding you up, Senator Spruill, and we haven't had this bill for a couple of years.
Mr. Chair.
Senator Vogel.
I just have a question, and this would, in my view, be a reason to at least explore this a little, because I'm reading this, and when you look at some of the definitions, for example, this does not say minority groups. It's talking about racial or ethnic groups. And so when you look at the breakdown, I'm not exactly sure that this accomplishes even what it is we're trying to accomplish. If we look at the baseline definitions, that are we certain that these covered jurisdictions actually exist under this definition?
Are you looking at line 37?
Yes, because we're talking about 2 or more racial or ethnic groups. It doesn't specify minority groups, and I think that's part of what it is that we are trying to be careful to cover here. Because if you look at some of the cities in the Commonwealth of Virginia where I think we would want this to apply, that's relevant. But in any case, I had not had a chance to read this as closely, and I fully appreciate what it is that the patron's trying to accomplish, and absolutely understand the value, but I was just raising that as yet another reason. And again, whether we put it off a year as a reenactment clause or we put it off another year to work out the kinks, I do see some value in some further discussion.
What you're talking about with 2 or more racial or ethnic groups on line 19, you're talking about a majority and a minority. Is that correct?
19? Yeah. I mean, if there's 2 or more racial or ethnic groups, there's going to be one of those groups that falls under the definition. I mean,
one's a majority.
That's by nature.
Yeah. Okay.
Yeah, I mean, I appreciate the senator's comment, but I think it's moot.
Senator
I
Spruill.
hate to keep speaking. Everyone in this room know when you say racial minority, everybody know good and well of those 2, you're talking about black folks. Everybody in this room knows. Look at them shaking their head. Look at the white folks shaking their head. Come on now. I mean, you playing with words. Everybody knows. He said racial minority group, that you know you're talking about some black folks. You know that. So you want to put that in there, minority groups? I don't think I'm a minority because I got much than anybody else got in here. But you know when you say those two words, you know one of those things got to talk about black folks.
Senator, I guess I would close by saying that the value of the delayed enactment over a reenactment is that the delayed enactment allows the AG's office to start the process of getting this ready. And this has been a bill that's been vetted by a lot of lawyers, a lot of groups, a lot of committees. I understand, it is delayed. It is a delayed enactment. I think the language is tight. I understand your reticence. But it is delayed. It is something that I think we should be moving forward with. To Senator McClellan's point, I think she's right. And I think if there's a definition that's off or a word that's off, which I don't think there is, but if there is, I think it's still something that we can address moving forward.
Mr. Chair,
Senator McClellan.
if the purpose of an amendment is to put the bill in conference, I offer the following. On line 90, strike July 1, 2021, and put January 1, 2021.
You're moving it up 6 months?
I'm putting an amendment in to get it into conference.
This substitute was not what came from the other side. This is a substitute that's just been offered to this committee.
Well, if you want to say January 1, 2022, but my understanding is he wants this substitute. And if the purpose of, someone asked about a reenactment in order to get this into conference.
January 1, 2022 would make me more comfortable.
That's fine.
Okay.
So moved.
Second.
Okay. Does everybody understand the amendment? On line 20, or line 90, July 1, 2021 would become January 1, 2022. Does everybody understand that? All in favor of that amendment, say aye.
Aye.
Okay. Any opposed? Okay, the bill's before you.
Second.
Okay. Are there further motions, further discussion? It has to go to finance,
Yeah,
so the
that's what it
motion is
does.
to report and re-refer to finance. Okay. Open the electronic voting machine, please.
Ten ayes, 5 nays.
Okay, the bill is reported and re-referred to finance.
Thank you, Mr.
Okay,
Chairman.
is that
Thank you,
your
members of
last
the committee.
bill?
That is it.
Okay, Delegate Levine, do you want to do yours?
I am ready now.
Okay.
Thank you, Mr. Chairman, members of the committee.
And you just have one bill, or?
I have just one bill before you.
Okay.
HB 177, the National Popular Vote Bill. This is the bill that allows each and every citizen of the United States the equal right to elect the President of the United States. It's a bill that has a lot of support. Poll in Virginia showed 74% support in Virginia. That's 2% higher than the national poll, 72%. In fact, polls have shown ranges from 67% to 81%. You may be surprised. I looked up the 3 states with the highest support for the national popular vote. There were only 3 that were 80 or over. Arkansas was 80%, Kentucky was 80%, and the highest of all, 81%, was West Virginia. That may surprise some people. These are states that are traditionally Republican states. These are smaller states. Why do smaller Republican states support this? Because nobody comes to see them in presidential elections. In the last presidential election, 4 states had 60% of all campaign visits. And in fact, the tiny state of New Hampshire had in the general election, not the primary, in the general election, more visits than 35 states put together. So why is everyone going to these states? The reason is because it doesn't matter how big your state is. It doesn't matter how small your state is. All that matters for the presidential candidates is if your state is close. So yes, 60% of all campaign events were in Florida, Ohio, North Carolina, and Pennsylvania. A lot of Americans' voices aren't getting heard. And so, again, this isn't a small state, big state issue. Small states like Delaware, D.C., Rhode Island, Hawaii are part of the compact. What this is about treating every American with respect. And I would say with regard to Virginia, the people who are being most mistreated by the ancient electoral college system were the Trump voters. Again, that may surprise people that I make this argument. But if you voted for Donald Trump, in Virginia in 2016, then your votes weren't counted at all, because every single electoral vote went to Hillary Clinton. Now, the same is true of Democrats in Texas or Republicans in California or Democrats in Mississippi or Republicans in New York. A lot of people just don't vote because they know their votes aren't being counted. In fact, we have one of the lowest, maybe the lowest, participation rate in the democratic world. About 55% of Americans vote for president. And we all know the reason why. I'm from Tennessee originally. I talked to people in Tennessee. I said, did you vote in 2016? Nah. What's the point in voting? My vote doesn't count. I know Tennessee's going for the Republicans. I talked to people in D.C., just across the river from Alexandria. Did you vote? No. My vote doesn't count. And here's the sad thing. They're right. I tell them, well, you should still vote. There's local races, there's state races. Nah, I only vote for president and my vote doesn't count. So they are rationally choosing not to vote in this great country of ours. We can change all that. We can make every vote count.
Yeah, this is identical to Senator Eben had the same bill earlier that was struck in this committee. Is that correct?
I believe so.
Okay, and the bottom line of the bill is that you're basically doing away with the Electoral College without doing away with the Electoral College.
Yes, what it does is it uses Article 2, Section 1 of the United States Constitution, which says that the legislature decides where all the electors go. And it uses them to say that if states totaling 270 electoral votes, namely the majority, the ones who decide the election, if that many join the compact, then they look at all 50 states in D.C., they add all the votes together, and they give their electoral votes to whoever wins the national popular vote. Now, we already have 196 electoral votes. We already have 16 states in D.C. that have signed up. Virginia would bring it to 209. It's very unlikely this would happen by 2020, to be fair, because we would need 61 more electoral votes by July 20th of this year. So I admit that's unlikely to happen, but it certainly could happen in time for 2024, and we could give every person a right to vote. You know, the whole winner-take-all system, that was not part of the founders' vision. The founders' vision, as we know, was that a bunch of, well, let's face it, wealthy white men who had property, and frankly, they got 3/5 more of a vote if they were slave owners, could get in a room and choose the president. And the founders didn't believe we'd have political parties. They think they would just decide based on virtue. Well, the founders didn't get everything right. 10 years later, they were wrong. 10 years later, they had the Adams-Jefferson race, and we had political parties, and we were off down the road. The whole idea of the winner-take-all system didn't come till about 50 years later. So people who say this isn't the vision of the founders, well, they didn't predict the winner-take-all system. They didn't predict a presidential election where 46 states got very few visits. And in fact, the majority of states got no presidential visits at all. So I think this will fix a real problem. I think it will allow every American to participate in our democracy. And here's the thing. It doesn't matter if you're a Democrat in Mississippi or a Republican in California. Your vote will count if we have the national popular vote.
Senator Howe.
I just would like to move to report.
Well, and so there's a motion to report, but first we want to see if there are people here that want to speak to this issue.
Mr. Chair,
For
I just
or
have a
against?
question.
Senator Reeves has a question.
So what do you do with the states that don't opt in and you have a close election and a recount? What happens then? What if those states don't report? How does the recount work?
So, Mr. Chairman, I understand the question to be if states don't report their election results? I'm not sure I understand the question.
Well, if you have a popular vote and you have some states that write a bill and they say, we're not going to report it to you. Maybe it's Texas and Georgia. I don't know, pick a state. And they don't go along with this.
Okay.
What do you do on a close recount?
So, Mr. Chairman, I would say that I've never heard of a state saying we're not going to count the votes. Texas and Georgia both have statutes that say we count every vote. And they count them, and they have recounts, and they've done full state recounts. And all 50 states, they may have a governor's race. I've never heard of a case where a state says we're going to refuse to allow any of our voters cast any vote for president. I think that'd be a pretty extraordinary thing. But basically, there's elections in all 50 states. In fact, I don't think they can legally do that because once a presidential ballot is there, those states' laws require them to have an election. They'd have to kind of shut down the election, and I don't think a lot of Texans and Georgians would be happy if they shut down the presidential election in that state. That's a pretty unusual hypothetical. It hasn't been posed to me before. I just don't think Texas and Georgia, I don't even think they'd be allowed to pass a law saying we're not going to have a presidential election because the Constitution requires it.
But Delegate Levine, how many states have to pass this for it to become effective nationwide?
Yes, so it has to have states totaling 270 electoral votes. So if Texas and Georgia don't join the compact, if that's the question, then this works just fine. Because if states totaling 270 join the compact, they look at the total vote of all 50 states, and they cast their 270 in a block, whoever wins the national popular vote, and it really doesn't matter how the other states cast their electoral vote, because the winner of the popular vote wins the election.
So how many states, how many electoral votes have adopted this?
We have 196 electoral votes now. 16 states in D.C. have approved this. This goes back to 2006, 2007. This isn't a recent phenomenon.
What's your deadline to have it affect this fall's election?
July 20th of this year.
Do you think that'll happen?
I think it's unlikely we will get 270 electoral votes by July 20th.
This is more likely to happen for the 2024 election?
It's more likely to happen by the 2024 election,
Okay.
yes, sir.
Okay, well, there's a line of people behind you, unless you've got more questions.
Mr. Chairman, I have a question.
Senator Spruill's got a question.
Couple of questions. Number one.
Yes, sir.
Then suppose Virginia popular votes goes for someone else, and we opt out. Then do we have to vote for Donald Trump? Would our electoral votes go to Donald Trump?
So the way it works is if there are not enough states that join the compact, if we get to 269, we don't get to 270, then everything stays the same way. Virginia casts its votes. We do winner take all in Virginia. And the election of 2020, for example, will be held exactly as every other election that's been held in the last 100 years. This only goes into effect.
I'm asking about Virginia. All I'm saying is
so if Virginia, whether Virginia joins the compact or not, unless we get 270 by July 20th, we're going under the old system. But let's say Virginia joins the compact or not, frankly, and enough states join the compact by 2024, then we're in the national popular vote system.
So and don't count.
So we count as individuals, voters. Every vote counts. Every Democrat, every Republican, every voter in Virginia has their vote counted towards the national total. And that would be true for every one of the 50 states.
Senator Spruill.
It's a question then. So that means we are doing away with electors. All right? So by doing it this way, we're doing away with electors.
Well, technically the Electoral College would still be there, but in effect it would be the same result as doing away with the Electoral College, yes.
Thank you.
Now, we've got a bunch of people, and I'd ask you to be very succinct if you can.
Thank you, Mr. Chairman, members of the committee. My name is Jamal Bowie. I'm a columnist for the New York Times, but I'm here specifically as a resident of Charlottesville and a native of the state. I want to speak to the concern around national popular vote that involves political minorities, that they might be swamped by larger states, that they may be swamped by political majorities elsewhere in the country. And the fact of the matter is that right now, under the winner-take-all electoral college system, if you are in the political minority in your state, if it's a 50.1, 49.9 election, if you're in that 49.9, your vote does not count. I think that's especially acute for racial minorities. In Virginia, up until 2008, Republican Party presidential candidates won the state's electoral votes, regardless of how many African Americans voted for the Democratic candidates. That was the case throughout the South. And the absence of any way to count those votes and have them really matter for the outcome effectively disenfranchised a large portion, and at one point a majority, of black voters in the country. And that is true for many different groups of voters. So I want to conclude by saying one way to think about this is it is making the votes of every single group, regardless of their relative place in their state's electorate, it's making those votes equal. Thank you.
Thank you very much.
Hello, my name is Pam Berg. I am a resident of Alexandria, Virginia, and I am a constituent of Senator Abin Eban. Adam Eben and Delegate Mark Levine. I am here today to speak on behalf of the League of Women Voters of Virginia. Chairman Deeds and committee members, the League of Women Voters of Virginia asks for the committee's support of the National Popular Vote, HB 177. For the past 100 years, the League has been guided by our core principles, one of the most cherished being that every citizen should be protected in the right to vote. Today, we continue the fight to ensure that every vote matters when electing the president. One person, one vote is an idea every Virginian and every American can get behind. The time has come for our president to be elected in this just and simple way. To pass this bill now is to be on the right side of history. Thank you.
Thank you, ma'am. Yes, ma'am.
Chairman and Senators, thank you for giving me the opportunity today. I don't have to remind you that twice in the last 3 administrations, the president was chosen by a minority of the vote. But due to the Electoral College, they were elected. This general election, the winner of the presidency will be decided by 4 states: Wisconsin, Michigan, Pennsylvania, and Florida. Please, let's make this the last time that only 4 states decide who will be the winning candidate for presidency. Thank you.
Thank you, ma'am. That puts this election behind us. I'm sorry. Yes, sir.
Thank you, Senators, and Chairman. Thank you. My name is Jeffrey Jacobs. I'm from Herndon, Virginia. And I want to remind you that we all know what happened in 2016. We all know what happened in 2000. Do we know what happened in 1888? Do we know what happened in 1876? Do we know what happened in 1824? Thank you, Senator. And do we know what happened in 1960? Because that election was very close too. And it was, of course, ceded to Kennedy. And, of course, in 2004, we almost had that happen again. So this is a problem that affects both Democrats and Republicans. It is not a partisan issue. And we ask that you consider this and pass this resolution. And finally, I just want to point out that this is a situation, in a way, that our nation is, in a sense, gerrymandered. Consider Bristow, Virginia versus Bristol, Tennessee. These are 2 communities, like communities, that are separated. Now, at the state level, and at the congressional level, at the legislative level, that makes sense. But at the presidential level, that doesn't make sense. They're a like community. They should be considered as one community, and that is essentially done through a national popular vote. Thank you.
Let me ask you, though.
Yes, thank you,
in a close election like 2000, instead of having a recount in Florida, wouldn't you have to recount in a lot of close states?
Well, interestingly enough, what would happen is the states that were close would have to recount. The states that weren't close would not actually technically have to recount. But if you had an exact tie for some reason, 655 million, 429, you had exact tie. And interestingly enough, what happens is we go back to the old system. We go back to winner take all in every state, whatever you had the law before the passage of the National Popular Voting State Compact.
Okay, thank you.
Thank you.
Good afternoon.
Yes, ma'am.
I represent Virginians for Medical Freedom, but since everyone's throwing race around, I'm a minority woman, as you all can see, and I'm in opposition of this bill. Our nation was not created on a whim. It was founded on proven principles dating back to 1014. The genealogy of our Constitution includes the 1100 Charters of Liberty, the Magna Carta, the English Constitution, and so many other foundational documents and works like those of John Locke, which created a nearly perfect and very limited servant government. With lots of scrutiny, this wasn't on a whim, a bunch of white men getting together, we're rich, let's do this. With lots of scrutiny and thought, our framers chose a Republican form of government, not a democracy. We, the people, created government as a servant to stand in for us when we can't. I am here to tell you that you don't have the authority to change a foundational principle that makes up how this republic functions. Going from electoral to popular vote fundamentally changes our system. Our system formed from a Republican form to a government to from a Republican to a democracy, where the mob rules, which is why our founders chose against it. If you believe in the popular vote, you believe in collectivism and in slavery. Let us not forget that the popular vote is what kept slavery alive and well in America, especially in Virginia. Those who want this bill do not truly understand our form of government or our history. They don't love liberty if they are okay with liberty being in the hands of the mob. Your oath of office made the Constitution your job contract, and you became public servants to the people. Anyone who votes for this bill is committing the crime of treason, so be on notice. You cannot claim ignorance of the law of the land, which guarantees to each state a Republican form of government. You are entrusted and paid on the basis of your sworn oath to support and defend it, not to legislate over it, and ignorance of the law is no excuse. John Adams said, "Remember, democracy never lasts long. It soon wastes, exhausts, and murders itself. There never was a democracy yet that did not commit suicide." Thank you.
Yes, ma'am. Where'd you say you were from?
Virginians for Liberty and Justice.
But where do you live?
I'm in Fredericksburg.
Fredericksburg. Okay, thank you, ma'am.
Thank you.
Chairman, members of the committee, my name is Nancy Kolb, and I live in Radford, Virginia, and I'm here to speak in favor of national popular vote. And my reason is a more modern reason, that I believe that a national popular vote is our best defense against computers, Facebook, and foreign powers taking over our elections. Computers are getting so good and getting better every year that they can identify exactly the right 1,000 people that are persuadable and then target those people with misleading Facebook and other media ads. So elections in the modern times have become, to me, a large computer game, and we don't even know what countries are playing. So I believe that if we went to a national popular vote, it would be much harder to find persuadable, gullible voters to target to overturn the will of the majority. Thank you very much.
Okay, thank you, ma'am. Yes, sir.
Hello, my name is Alan Guest Jr. I live in Boynton, Virginia. That's down Mecklenburg County way. Senator Ruff's my representative. And I'm here to speak against the national popular vote. Power diffused is liberty preserved. And we would want no more someone telling us what car to drive, what color to paint our house, than we want someone else telling us who our leaders should be. As was stated, the Electoral College was designed to protect the little guy from the big guy. I believe Franklin once said that a Republican form of government are two wolves and a sheep deciding what's for supper, with the heavily armed sheep contesting the vote. The national popular vote will, as history in some cases has proven, well, all cases has proven, that the majority will then swallow the minority. Thank you.
My name is Joshua Pritikin. I live in Short Pump in Henrico, and I'm here to speak in favor of the national popular vote. Thank you.
Thank you, sir. Yes, sir. Yes, sir.
Thank you, Mr. Chairman. Members, my name is Ray Haynes. I'm here on behalf of the National Popular Vote Organization. I did want to answer your question and Senator Reeves' question with respect to recounts and the reporting.
Where do you live?
I am actually from Sacramento, California.
Okay.
So I served in the Senate of the California legislature. In fact, if you go on to
Has California adopted this compact?
Yeah, I was just going to get to that. If you go on to YouTube, you will find my speech opposing the National Popular Interstate Compact on the floor of the California legislature. I'm a Republican, a conservative Republican, that has come to the conclusion this is what's best for the conservative movement, for the Republican Party, and for the country as a whole. I will say this, to Senator Reeves' question, no state under federal law, states are required by a certain period of time to report their certificates of ascertainment to the federal government, and then those certificates are opened on the counting day in front of Congress. And that procedure is set up. If you get into the Bush v. Gore decision that came out of the Florida election, they said the certificates of ascertainment are required to be filed 6 days before the meeting of the Electoral College, and it reports the state's vote, and it also reports the awarding of the electors.
Senator Spruill's got a question.
Sure.
Did I understand you said that this is best for the conservative, best for the Republican Party as a whole?
That's my conclusion. That's why I support it.
You just made my champion, and you just gave me my right to vote, Doc. Heck no, thank you.
No, I didn't intend to do that. That's why I say it's best for the country as a whole. But as a Republican, that's my opinion. That's why I had spoken against it on the floor of the Assembly in California. But the bottom line on the thing, with respect to the recounts, recount law stays in each state as it is. I want to make this clear because you had made the comment, does this effectively get rid of the Electoral College? And no, it doesn't. In fact, it preserves the Electoral College while at the same time making every single vote in every single state important in every single election. Why is it important to preserve the Electoral College? Is because the Electoral College is what keeps states in charge of election law. Article 1, Section 4 of the Constitution puts the major authority for determining election law in each of the states. So recount law stays in the hands of the states. So any state which is close enough for a recount will still recount. What Bush versus Gore said was it has to be finished by 6 days before the meeting of the Electoral College. So those are those technical questions. The last thing I would say is the biggest challenge I know for some folks will say, well, the rural areas will get crushed by the urban areas. The fact is, rural areas in Florida and rural areas in Ohio, rural areas in New Hampshire have a lot of power. The rural areas of Virginia do not, now that Virginia is no longer a battleground state. If you really wish to protect the rural areas of Virginia, this is the way to do it, because now a vote in rural Virginia is as important as a vote in rural Florida. Thank you, Mr. Chairman.
Thank you, sir. Yes, sir.
Thank you, Mr. Chairman and members of the committee. My name is Scott Drexel. I'm here on behalf of the National Popular Vote Organization. I've been working on National Popular Vote for about 10 years. I think I've probably visited about 35 different states to discuss National Popular Vote. Just to avoid repeating some things that have already been said, I did want to address one question.
I appreciate that.
You had at the very beginning of the hearing. And I think to envision National Popular Vote as some kind of workaround or some kind of gimmick to get around the Constitution is to err in what the original intent of the Electoral College was. The Founding Fathers did not discuss the winner-take-all system at the Constitutional Convention. It is not in the Constitution. They were dead by the time the winner-take-all system had come into prevalent use by the 1830s. The reason the Constitution or the founders did not specifically enshrine the winner-take-all system in the Constitution is because it was left to the state legislatures. This is how it was supposed to be done. So thank you for your consideration.
I appreciate it very much. Thank you. Yes, ma'am.
I'm already.
And I appreciate it. You know, you've heard everybody else talk, and please
Yes,
don't
sir.
repeat what's been said.
Yes, sir. I have actually a couple of different points that I wanted to make. My name is Artie Skinner. I'm from Falls Church. And I actually have a handout which is available to all the senators if you're interested. Yesterday, I chatted with the NPV staff on Facebook, and that chat is shown on the handout. We chatted about two of my concerns. First, the NPV acknowledges that the compact has a problem called the spoiler effect. And Senator Spruill, this goes directly to your point. This spoiler effect occurs when a third party splits the votes nationally for either party. In this situation, Virginia could choose one presidential candidate, and the national split vote could cause the opposing candidate to win all of the national vote and thereby all of Virginia's electoral votes. The second issue we discussed is the number of logistical issues that need to be cleared before the NPVIC could be effective. And I emphasize the NPVIC because it's a compact. It is not really the national popular vote. It uses a national popular vote, but it is actually a hybrid between the national popular vote and the Electoral College. And because of that, there are a number of logistical issues. This is primarily due to differences in the way elections are handled between the states. The NPV admitted that they consider the NPVIC to be a beta test until a better process can be found. I submit that we should not take such an enormous risk with a beta test on a presidential election. On the back of the handout is a chart from the NPV Facebook page. This chart shows that once NPVIC has 270 electoral votes, there will be 268 electoral votes that are described as not mattering. The people in these states will not agree that their votes don't matter, and they will file litigation that will result in further delays in our presidential election. I believe the NPVIC is an enormous risk to Virginia and to our country, and I ask you to please vote no on HB 177.
Thank you, ma'am. Yes, sir. Yes, and I understand that everybody wants to be heard. I'd appreciate it if you'd keep it very short.
I'll do my best. Mr. Chairman, distinguished senators, you're probably tired of seeing me appear before this committee as well as also in the House. But this is very concerning to me. Reflecting what it is that my spouse, by the way, my name is Maurice Skinner. I'm from Falls Church, Virginia, Senate District 35. The idea that it's like the NPVIC promises a lot of things, but I don't think it's ready for prime time. There are a lot of details, as were described before, and that is just the process and the discrepancies between how a national popular vote would be counted. You have differences between states regarding whether or not prisoners are allowed to vote or not. Not disputing whether or not they're entitled to vote or not, but just simply saying there's a wide degree of discrepancy between those. So either way, trying to come up and calculate this national popular vote will be quite difficult just in itself. But either way, I think it deserves a little bit more study before this thing goes live, and that is that if it is a beta test, it really should not be, because that sort of disrespects the presidency and would also delay quite significantly our seating of an elected official. So either way, with that, I'll end. Say thank you very much for the opportunity to speak.
Yes, ma'am.
Eileen Reevy, speaking on behalf of National Popular Vote. I would just like to clarify that this is not our organization's Facebook page. Our handle is just at National Popular Vote.
Where do you live, ma'am?
I live in Oregon. So I just want to clarify that.
Thank you. Yes, sir.
Good afternoon, Mr. Chairman, members of the committee. If you'll allow me, I'll try to get 4 quick points and get out of your hair. Number one, about recounts, it wouldn't just be individual states that need to recount. The whole country would have to recount. Because, as it is now, if there's a close vote in one state, yeah, you have the recount. But if every vote is to count, logically, you'd have to recount every single vote cast in the country, right? It's not just a state by state at that point.
But the states run elections.
Right.
Right.
But it wouldn't be an equitable recount if only some states. So anyway, number two, talking about motivation to vote, everyone's vote to count, and people, red voters in deep blue states would now be motivated to vote and vice versa. That already happens. Or else, for example, in Virginia in 2008, Democrat voters wouldn't have ended 40 years of Republican victories in Virginia. So people do have motivation to come out to vote. Candidates motivate people, not the Electoral College or a popular vote. And the same with voters last time in Wisconsin and Michigan who hadn't voted Republican in years. So motivation isn't the system, it's the candidates. Thirdly, as John F. Kennedy said in a 1956 Senate floor speech, when there was a constitutional amendment proposed to abolish the Electoral College, this would create all sorts of unintended consequences. Maybe the goal is good of getting 50% for the winning candidate, but it wouldn't do that. We would be more like France, where they have a multiplicity of candidates. And, France, talking about disenfranchised voters, their last election, about 40% of the people...
Please,
Yeah.
hurry it
okay.
along.
All right, well, we almost got Marie Le Pen because of splintered votes, okay? That's that. And then lastly, if the system is so bad, the city of Richmond, about 10 years ago, 12 years ago now, adopted an electoral college system to elect the mayor. In order to get elected mayor in Richmond, you have to win 5 of the 9 council districts. And that's because you want broad-based support of the winning candidate so he or she will have a mandate. Thank you, Mr. Chairman.
The end of the line. Yes, sir. Thank you very much. Yes, sir.
Thank you. My name is Sean Parnell. I'm with Save Our States. We're a national organization focused on defending the Electoral College. I am a Virginia resident. Senator Servell is my senator. I've spoken with him about this. So the basic problem with national popular vote is that it denies Virginians the right to decide how Virginia's electoral votes will be cast. Just like our U.S. senators are supposed to represent us, just like Senator Servell is supposed to represent me and the people in my community and not the people in Southwest Virginia, our electors are supposed to represent the interests of Virginians. And under national popular vote, that very obviously is no longer the case. I want to just reply to a few questions that have been asked, and then I will leave the committee alone. So the question of recounts. Those of you, I think all of you probably remember Florida 2000. One of the critical issues was that a lot of people were outraged over the idea that only some counties might be conducting recounts, and some might be counting the pregnant chads while others are not. Some might be going through the absentee ballots that maybe didn't meet the postmark requirement while other counties would not. That is literally what you are going to have on a nationwide scale if you have a close vote under national popular vote. You will have some states doing recounts because they will look at their state laws, or more realistically, their judges will look at their state laws and decide, yes, we will do a recount, while other states, their judges will look at their laws and say, no, this doesn't really meet our requirements because our state laws are built around the idea of counting votes that are in our jurisdiction. So you're going to have incredible chaos and anger when you have some states doing recounts, other states not, especially if that recount winds up changing the result of the election. Imagine if Georgia and Texas are doing a recount, and Texas has a very broad recount request standard, and other states like California and New York are not, and that winds up flipping it because another 100,000 votes turned up between Texas and Georgia and maybe a few other states as well. You're going to have a crisis of legitimacy that I don't think anybody wants to live through. As far as states withholding votes totals, the question isn't do states count their votes. The question is, I'm trying, Senator. This is a very complicated issue.
And it is complicated, and we've already had one of these bills that didn't make it out of this committee.
Mr. Chair.
And it's my hope that's the case. Senator Howe made a motion a little bit ago to report, and it wasn't seconded.
Make a substitute motion.
Okay. What's your substitute motion?
My substitute motion is out of respect for Article 2, Section 1 of the Constitution, and for the reasons he stated, I would make a motion that we pass the bill by indefinitely.
Mr. Chairman, am I done?
Yeah,
I'm happy to be done, given the direction I sense this going.
This motion wasn't seconded, so your motion was.
Mr.
Senator
Chairman?
Vogel's was a primary motion. Senator, you've got a substitute motion.
I have a substitute motion, move to carry it over, come back this next fall, get together and really explore this bill further.
So the motion's carry over in a second, okay?
Second that, Mr. Chairman. Speak.
That's a substitute motion. It takes precedence.
Mr. Chairman.
Yes, takes motion over the Senator Servell.
Thank you. Speaking to the motion, I think this country has a real problem on its hands right now. I mean, first of all, I'm delighted to have been called a treason in my Commonwealth for the second time this session. So really appreciate that. But in any event, now that I'm a traitor, I'm going to keep that up and double down. What I'll say is a couple things. We got a real problem in this country. Al Gore got 540,000 more votes than George W. Bush. And of course, it was decided by 1,000 grandmothers in Florida somewhere or something that couldn't read a ballot right. But Hillary Clinton won her election, or got 2.87 million more votes than Donald Trump. Two of the last, 4 presidents have been elected by somebody other than the majority of this country, and it's a real problem. And when I look at the reason You know, when this electoral college was created, the United States of America had about 40% of the population of the Commonwealth of Virginia's population today. I looked it up. George Washington's first election, 43,000 people voted out of 3 million. And this state had 2.4 million, or I'm sorry, the country had 2.4 million people, 600,000 slaves on top of that. And only 43,000 people were voting in our system back then when this system that we're still stuck with was designed. So 43,000 people picked the people who picked the people. And from my perspective, and I know there's a bunch of conservative commentators that disagree with me because I've read their commentators, but the Electoral College, from my perspective, has racist origins. The Electoral College was a way for Southern slave states to maintain their power in the presidential election because slaves were counted in terms of the congressional counts that make up the Electoral College weights, the weights that votes are given in the Electoral College. And it is a system which has no longer should have any bearing on us, but I understand that undoing a constitution is really hard. And from my perspective, this is the best way to bring real democracy to this country, because I think when most people vote for president, they think they're voting for president and not for an elector to vote for president. We need to do this.
Okay, with that, thank you. The motion is to carry over. Open the roll. Vote yes is vote to carry over.
14 ayes, 1 nay.
Okay, thank you.
Thank you, Mr. Chairman. And when we carry it over, I want a chance to address a lot of things that were
Well, we
incorrect.
will hold a carryover meeting sometime in the fall.
Excellent. Thank you very much. Thank you, Mr. Chairman, members of the committee.
Thank you. Okay, the next person on the list is Delegate Willett. Your bill is 232. Is that your only bill?
That's right, Mr. Chairman.
Okay.
Thank you very much. Good afternoon. Mr. Chairman, compared to Delegate Van Valkenburg's preclearance bill and Delegate Levine's popular vote bill, this is a much more complicated and complex issue. So that's a joke.
I appreciate that.
No. No, in a nutshell, this bill, HB 232, would ask the Department of Elections to provide voter registration forms to college students who are receiving the Virginia Tuition Assistance Grant money. This was an issue that was brought to me by a constituent, just basically saying why not meet the students, the voters where they are and make it easier for them to get the voter registration forms. The State Council on Higher Education of Virginia, SCHEV, would work with the Department of Elections to give them the names of the schools that are participating or receiving VTAG funding and help in the process.
So the whole idea is just to give voter registration forms to kids who receive TAG grants?
Absolutely.
Okay. Are there any questions for Delegate Willett? Are there people here who would like to speak for or against the bill? The bill is before the committee.
I move to report.
I've got a motion and a report and a motion and a second to report. Are there any further motions or is there other further discussion? If not, open the roll.
Nine ayes, 6 nays.
Okay, the bill reports. Thank you.
Thank you, Mr. Chairman.
Thank you, Delegate. Next is Delegate Sullivan. Delegate Bourne. Delegate Cole. Delegate Price.
Yes, and which would you like to start with, Mr. Chairman?
Well, it's your choice, whichever you like, whichever you prefer.
Okay. If we will start with House Bill 1255.
Okay. So you've got 3 bills all told, right?
Yes.
Okay, 1255 is basically identical to Senate Bill 717, which was our criteria bill. Is that correct?
Yes, but Mr. Chairman, I do have amendments that would then make it exactly identical.
Okay.
Mr. Chairman, sorry, we needed a technical substitute. There was a drafting error where 2 code sections were put out of order, so the substitute will just put them in the correct order. We did the same to Senator McClellan's bill in the House.
Okay, and the substitute would make this identical to Senate Bill 717?
Yes, as it reported out of House Peony.
Okay. You want to distribute copies of the substitute. We have a substitute before us. Is there a motion? All in favor, say aye. Okay, and finance wants this, it's my understanding they do if we decide to report this. Okay, this is just the criteria bill.
Mr. Chairman, was it 1255 or 1256 that finance wanted?
1256. 1255, they want all these bills.
Oh, okay.
They want them both. They want these two, 1255 and 1256. They wanted the Senate bills too. We had to send those to the Finance Committee from here.
Mr. Chairman?
Senator Spruill.
I know our council asked us to every meeting, why we keep sending bills to finance when there's no need to send it up there? Why we keep doing
Senator
that?
Spruill, I don't understand. I think they've got a chair that just wants, who's got the staff that wants all these bills.
Yeah.
I don't know what the answer is.
Mr. Chair,
Senator McClellan.
I would just say if it gives Delegate Price comfort, I was the patron of the Senate version, and I also sit on the Finance Committee.
And your bill went to the Finance Committee too, didn't it?
And I support it, and I sit on finance.
Right. So I think you'll be okay.
Mr. Chair, I heard a conspiracy rumor that the Finance Committee gets paid by the bill.
I believe that. I believe that.
I believe that too. Okay, you I think we understand the bill. It's just like the criteria bill we had before. Do we need further discussion on the bill or ask questions? If not, is there a motion?
I move to report and re-refer to Finance.
Second. Okay, there's a motion and a second to report and re-refer to Finance. Are there further motions or further discussion? If not, open the roll. I do. I'm sorry.
9 ayes, 6 nays.
Okay, that bill's reported. You want to do 1256 or 198?
Either's fine.
Whichever.
Okay, 198. So, Mr. Chairman and members of the committee, as you'll remember, in December of 2017, Virginia ended up on some late night comedy shows because of the 94th District Representative's name being chosen from an all but beautiful bowl. And that is when we learned that a lot of states across the country choose their representative when there is a tie in a recount in one of three ways. The legislature chooses, they do it by drawing by lot, or it goes to a special election. And so we did a little bit of research, and the by lot provision that we have in our code dates back to 1785. And so in just thinking about what the differences were between 2017 and 1785 and even to today, and checking with Republicans and Democrats all over the 95th District and the 94th District, there is a sense that the people want the power given back to them in a special election as opposed to their elected member being chosen by luck and out of a bowl. And so 198, there is a substitute that will clarify. The Constitution basically puts into place where the governor, lieutenant governor, and attorney general, how that process is handled. So these amendments and the substitute just clarify that it's not for those.
We've got a substitute. Is there a motion on the substitute? Motion and a second on the substitute. All in favor, say aye. Aye. Okay, the substitute is before us, and the bill says that this doesn't apply for governor's races, attorney general, doesn't apply for statewide races.
Right, and that's because their process is pretty much in the Constitution, and I really will defer to council if there is a more clear way to explain it. But this was the Attorney General's office that wanted some of these amendments just to clarify that it wasn't for those three races.
Delegate Price, I noticed that there are two other bills that are incorporated in here. There are three bills that were basically calling for this that were introduced.
Yes.
On your side?
Yes.
Okay. Are there questions for Delegate Price about House Bill 198. Delegate, or Senator Chafin.
So I would ask the delegate, what happens if there is a second tie? And I would say that if it's close enough to have been determined a tie, Mr. Chairman, the first time, then the odds of it being a tie the second time actually increase.
Yeah, so I would, excuse me, I would, Mr. Chairman, I would remind the senator that my colleague delegate, Marcus Simon, actually carried a bill that would limit the number of recounts that could happen. And so that would handle kind of like the backstop. And if there was anything else in the code that addressed that, I'm not sure. But this would not be the intent for there to be several special elections if there was another tie, because we have that backstop that we passed. The years are running together, but I believe it was in 2018.
The delegate, do you know what his Delegate Simon's bill would have called for? Or Meg?
I think it reverted.
I don't believe that bill actually passed, Mr. Chair. I think it got continued to the next year and for a study, and then we just never got back around to it.
So I do apologize. We might have passed it on our side, but it would revert back to by lot. I'm remembering the conversation from the previous committee, and I apologize for that. But yeah, it would revert back to by lot.
Okay, Senator Chafin, do you have other questions? No, sir. Okay, are there other questions for Delegate Price? Okay, are there those in the audience who would like to speak for or against the bill? Yes, ma'am.
I'm Barbara Tabb with the Electoral Board Association. Again, I'm not speaking for or against, but I have a couple of questions. I want to know who's going to vote in this recount. Is it going to be the same population who voted the first time? Is it going to be anyone within that district who now gets a second shot because they didn't make it to the voting point that they went the first time? Does it mean anybody who has registered since that vote, since Election Day, they get to come and vote on this because there's going to be a second election as well? So it's not the same as a recount if you have a revote, if you allow a different population to vote. So that needs to be really understood before we go through who's going to do this. Second is my same old horse you're getting tired of me riding in on, who's going to pay for this? You're going to ask the localities to pay for an entire new election for one seat instead of having a recount. That's our position.
Thank you, ma'am. Yes, ma'am.
Clara Wheeler, Albemarle County, and as I've said before, I was in the room when we pulled the vote out of the hat. And the bowl, it was a bowl, yes. I was following your lead on Saturday Night Live. I didn't see it, so I don't know. Ms. Tabb represents the Virginia Electoral Board Association, so those folks are well acquainted, I was about to say with grief, but I don't mean to say it that way, with elections. Elections are extraordinarily expensive. We do not know in Virginia. We've tried to determine, and we've not been successful in that determination. We don't know how much elections cost based on a Virginia Senate race or members of the House of Delegates or Board of Supervisors or whatever race we're talking about. We don't know how much they cost, but they're expensive and they're time-consuming. Ms. Tabb and I talked about this in the back. If you are passing this bill, you need to have clear definition of who's voting in this bill or in this recount re-election. Is it the people who voted in the first election and certainly may want to change their minds, but is it that population? Or do you let anybody who didn't see fit to go vote in the first election, do you allow those people to come and vote and get a second bite of the apple, if you will? And then you compound that by saying, are you going to let people register who were not registered when the first election took place?
Yes,
These are all considerations.
Ms. Tabb made all those points.
I know that, and repetition is the cornerstone of adult education. Thank you very much.
Mr. Chair.
Yes, ma'am. Senator McClellan.
Thank you, Mr. Chair. I have a question, and then, depending on an answer, a comment. Since 1785, how many times have we determined an election based on the Magic Bowl?
Or a hat.
Or a hat.
So, Mr. Chairman, I would say that I know of two.
So I asked that for a reason. Based on the past, I think the probability is high that going forward, this is going to be a very rare occurrence. But I think most people would much rather be given the opportunity, really we're talking about a runoff, which a lot of other states do, and the world doesn't end if they are not able to determine a winner. But here it's going to be very rare. But I think most people think that having chance decide the winner and taking that out of the hands of the people is anti-democratic. Now, if there are costs associated with this, my guess is that's something that the Finance Committee can look at. But in other states where a winner cannot be determined on election night, they have a runoff and the world doesn't end. And I think this is a much better option than the magic bowl for a probability of two new elections every 200 and some years.
Is there a motion wrapped up in there somewhere?
Yes, I would move that we report and re-refer to finance.
Sucking that.
It doesn't need to go to finance.
Oh, praise the Lord.
Then we just report the bill.
Okay, are there other motions or is there further discussion? If not, open the roll.
Nine ayes, 5 nays, 1 abstention.
Okay, 9-5, the bill's reported. And your last bill is 1256. And my understanding is this bill, if it's going to be reported, has to go to finance. There's a substitute for this bill?
No, that is just a handout. Mr. Chairman, we began discussion about House Bill 1256 last week, and so I am thankful for the opportunity to bring back before you a few additional points. I really sat and listened and really took in the conversation that the committee had with regard to House Bill 761 about the preclearance and the fact that actions have been taken as recent as 2019 that could have needed to go under preclearance. That, you know, around the conversation of the plus or minus 5%, we heard that the Voting Rights Act is so important, and even we heard a delegate say that the Voting Rights Act could actually be gutted. It may not be reauthorized because it's been authorized on partisan votes, and in 1902 the Virginia Constitution disenfranchised a whole race, and Section 5 was that safeguard. And because it was gutted, that's why there was a bill like 761. And so that was one of the main concerns that some of my colleagues and I have about the amendment, cross-referencing the Voting Rights Act as it is today. But a lot of us know that there are signals that this Voting Rights Act would not last as it is today in the near future. And so wanting to get to a better amendment with all of the host of reasons that I said before last week, that is what was the impetus to get to House Bill 1256. And so it has some differences. It has the similarities has the same selection process and committee structure. It has been amended to include that as the proposed constitutional amendment. But some of the conversation that we started to have, if you look at what was handed out, some significant concerns about, based on just hypotheticals, but based on the timeline that is allowed in the amendment, and based on previously what we've seen from the Department of Elections and kind of the time that they need to get ready, it shows you the different reiterations of when we would need a map in order to not cut into early voting and in order to not cut down on the primary season.
So if I can move it along just a little bit,
Sure.
The bottom line of this bill is this is an alternative to the constitutional amendment about redistricting. It basically creates an independent redistricting commission to draw lines and advise the General Assembly. That there are some differences, but it's basically the same thing that's in the constitutional amendment. It's just put in statute.
And Mr. Chairman, I would just give one small adjustment to what you said. I don't believe that we should be using the term independent when we're talking about any of the proposals that are before us, because there are legislative members on there, and it's also bipartisan. There isn't even room for independents at the table. So I would say that it is a legislative fix with a bipartisan makeup.
So, the makeup of the membership is basically the same that's in the constitutional amendment?
Yes.
8 legislators and 8 people that are chosen by judges, is that correct?
Yes.
Okay. Does everybody understand what's in this bill? I mean, it's been before us for a while. Have you looked at it? Does anybody have any questions of Senate Delegate Price? Senator McClellan?
Yes, Mr. Chair. Just based on a conversation that Meg and I had, I think there's a little bit of confusion about whether this commission can function regardless of whether a constitutional amendment passes. So my question for the patron is, if the constitutional amendment passes and we have this commission, would this commission just be advising the independent commission set up by the constitutional amendment? In other words, are they in conflict or not?
Mr. Chair, Senator McClellan, if this piece of legislation passed, HB 1256, and then the constitutional amendment was also passed by the General Assembly and then approved by the voters, they would be in conflict. There are provisions in this bill that would not be constitutional under the constitutional amendment.
Okay.
Mr. Chairman, I ask a clarifying question for what we just heard from council. So is it that one could exist and be superseded by, or that they could not exist because the other one does not start? The time frame for the elections results to be certified is several months after what 1256 would begin, where that would begin. So there is some period that they would not be in conflict. Is that correct?
That would be correct, but then as soon as the amendment was adopted by the voters and so the Constitution was amended, there would be provisions of this bill that would no longer be constitutional. As it stands right now, if this bill were adopted and the constitutional amendment did not get passed by the General Assembly or approved by the voters, then it is not unconstitutional, but it does not work with the constitutional amendment.
So, Mr. Chair, I asked Meg to prepare an amendment. I think there's a little bit of confusion about how this interplays with the constitutional amendment, and I know a decision down the hall has not been made yet on the constitutional amendment. I think this has merit, but whether this passes, whether this takes effect may be contingent on what happens down the hall. So based on that, I have an amendment I would like to move just to keep this conversation going.
And the amendment would basically require the constitutional amendment to pass for this to be effective, or would require it to pass the legislature for this to be effective?
Well, I asked for one, and Meg wrote another one based on, I think, how she thought they worked together. So what I wanted to do was, my understanding is whether the constitutional amendment passes or not, there could be an independent body that begins collecting data, talking to the public, getting public input on how the district should look, could draw maps that then could be given to the independent commission created by the constitutional amendment, if that passes, for their consideration or not. Or if the constitutional amendment doesn't pass, could be given to the General Assembly for their consideration or not. And so what I wanted to do was to say that this bill would take effect July 1, but to continue the conversation, say contingent on the constitutional amendment passing the General Assembly. I mean, as a practical matter, this is probably putting it in conference, but yeah.
Meg, I take it from your look of consternation, that's not exactly what you have drawn up.
It's not.
No, Mr. Chairman, my understanding from what was communicated was that it just needed to be contingent on passage of the amendment by the voters and did not realize that.
The way I heard Senator McClellan's motion, it would have to be contingent on the passage of the constitutional amendment from this legislature.
Right, so
And it would take effect July 1. And the beauty is you'd have somebody looking at this, getting ready for whatever the constitutional amendment for that panel.
I would say, though, that if this bill is supposed to operate in conjunction with a constitutional amendment, there would need to be additional changes made because this bill would be in conflict with the constitutional amendment should it take effect.
What I would suggest is if we can adopt this amendment, we're going to have to send this bill to the Finance Committee, and we can work on additional.
Janet's thrilled.
We can work on additional changes between now and then.
Great.
Chairman,
Senator Spruill.
could she tell me what other new changes need to be made in order for this thing to work?
If, Mr. Chairman, Senator Spruill, if this bill is supposed to operate in conjunction with the constitutional amendment, there are provisions related to how the bills will, or the maps that are adopted by this commission and then provided to the General Assembly, that language would be in conflict with what's in the constitutional amendment. The fact that we have a different timeline set out in this bill versus the constitutional amendment, that would also be an issue. So there would be some things that would need to be tweaked. And then this bill ends up looking pretty similar to SB 203 and HB 758.
Okay, but the constitutional amendment that we have is over in the House waiting on something now. So what would happen if we would put that same on this bill? We would have to do all that then if that's the case. The one that's in the House that they have on hold right now, what happens if we put that constitutional amendment on this bill?
I don't think we can put that constitutional amendment on this bill, Senator Spruill.
Okay.
I think, that has to be a resolution, which we've already passed.
Okay.
And let us say, and we've done what we could do.
Okay.
Now it's on you, it's in your body. So is that amendment pretty much that the bill will take effect July 1, but is contingent on the passage of this General Assembly of the constitutional amendment? Is that what you want to do?
Yeah, so what I'm trying to do is put it in conference. And so if that's the amendment we need to put it in the conference, then yes.
Okay, and is that the
Second.
amendment you seconded?
Second.
Yes, sir. Okay. Does everybody understand the amendment? All in favor, say aye.
Aye.
Any opposed? Okay, we've got that amendment.
And Mr. Chair, may I ask a question?
Senator
Just for
Vogel.
purposes of clarification, Meg will be able to make that change as an amendment to the prior bills where we added that amendment, correct?
What
To be
I'm
consistent?
hopeful, I'm hopeful that Meg, between now and the time the bill comes up in finance, Meg can figure out what changes are needed to make the bill consistent with the constitutional amendment.
Mr. Chairman?
Senator
I
Spruill.
understand, but you got the patron here. I mean, she at least know what we're doing. We're going to sit upstairs. She didn't know what we can do to her bill.
Mr. Chair, let me try. Sorry,
Senator
since I start this.
McClellan.
Here's what I want to do, and unfortunately, I don't have the amendment now to do it.
Okay.
My understanding of this bill is whether the constitutional, at least the patron's intent, and she can. Let me ask the patron. Your intent is whether the constitutional amendment passes or not, there would be an independent commission created by your bill that could begin work on July 1. Is that right?
That is how some of us have come to an agreement on the merits of the bill.
And based on what Meg said, currently that is not the form that this bill is in, but that's the form we want it to be in. So how about this? I think what we want is an amendment in concept that we can flesh out in finance. Maybe it's parts of the bill only take effect, depending on what happens with the constitutional amendment. But I think what we're trying to do is have.
Mr. Chair, Senator McClellan, if the intent is simply to get this bill to conference, any amendment will do. We can just change any word. Then when it gets over to the House, Delegate Price can reject it. I think the issue is that this bill was drafted to not have to have a constitutional amendment passed by the General Assembly or adopted by the voters. It was meant, as I understood it, meant to operate completely independent of a constitutional amendment instead of a constitutional amendment.
Well, and I guess the problem, here's the problem we're in. And maybe the patron can help me decide which way she would prefer. The Senate as a body has already taken a position on the constitutional amendment. I don't think a majority of the Senate is going to want to take a contrary view. But I do think a majority of the Senate thinks that the independent commission you've set up and the people on it and the work that they can do is valuable work that should happen no matter who is drawing the lines ultimately. So I think what we're trying to do is have a substitute that allows an independent commission to begin work on July 1st, whether a constitutional amendment passes or not.
So I would like to be able to address that. So, Mr. Chairman and Senator McClellan, I definitely appreciate the latitude that you all were willing to go to in order to continue this conversation. I think where I will have to exhibit some political courage is to actually ask that you not make that amendment to be fully transparent. There are fatal flaws with the amendment, and this was an attempt for us to be able to, with House Bill 1255 and 1256, say, we've got 2021 covered. Let's get to a better amendment that includes lots of the amazing parts of the enabling legislation that we came up with in a small work group that would allow for the language of the Voting Rights Act to be in there, that we could handle some of the timing issues that could put into question the integrity of our election and a lot of the other things that we talked about. So my concern is now asking council to do something that would end up not being constitutional. Should it pass?
I'm interested in trying to get the bill out of here, and it won't get out of here unless it has that clause on
Then
it.
I'm going to shut up.
Okay. The clause, I think we've already agreed to that amendment. And I would entertain a motion to report and re-refer to finance.
Mr. Chairman,
I'm sorry, Senator Howe.
I don't think, finance has not asked for this, has it?
It has,
Oh,
yes.
it has, okay, then,
Yes.
okay.
I mean, if you're telling me
The point that I want to make is finance is not a place to make a policy decision. It's a place to decide if you're going to fund it.
So why are we
if
sending it
we're
to
being-
finance then?
Because it does have a financial.
There's 1.5 million over 2 years for whichever option our General Assembly decides.
There's money attached because it's going to require work. That's why.
Mr. Chairman, I'm not talking about that
Senator
part,
Sproul.
Jen. I'm talking about the policy part of it. The money part, I can understand. I'm not talking, that needs to go to finance. I'm talking about that. But if we send it where it is now without it being clear, that means they got to do the policy as well, the finance part.
They're not going to do policy, Senator Sproul. My thinking is that as long as we can keep this alive, we can keep people talking about it.
Yes, sir.
And maybe find a way to get this passed.
Mr. Chairman, move to report and refer.
Second.
Okay. We've got a motion to report and refer to finance, re-refer to finance. Any further motions, any more discussion? If not, open the roll. Okay, thank you, Delegate.
Thank you.
Okay, Delegate Hudson, you've been sitting there for a long time.
Thank you, Mr. Chairman, members of the committee. House Bill 1116 is an agency bill with no fiscal impact filed on behalf of the Department of Elections. It simply streamlines the reporting process for results from party-run primaries. Under the current system, elect has to coordinate directly with local party chairs to receive the results on separate forms. Under this bill, that duty would be transferred to the state party chairs. They would collect all the results from all of their local chairs and then transmit the results to elect on one single form.
Okay, is there anybody here from the State Board of Elections that wants to talk about this bill?
Mr. Chairman, members of the committee, Jessica Bowman, Deputy Commissioner with the Department of Elections, want to thank the patron for carrying this. It proved to be some problems that happened you may have read about in the paper this past year, and we think this is a good way to solve it. So happy to answer any questions.
Okay, are there any questions for Ms. Bowman or the patron? If not, are there people in the audience who would like to speak for or against this bill?
Move the report.
Okay, motion to report in a second. Are there further motions or other discussion? If not, open the roll, please. Okay, the bill's reported. Delegate Sullivan.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman, members of the committee. This is HB 214.
214.
The genesis of this bill, Mr. Chairman, is a Fourth Circuit decision now more than 5 years ago. Has to do with who can circulate petitions for candidate signatures, who can be the person who signs the affidavit having to do with the signatures. There was a case named Libertarian Party of Virginia versus Charles Judd, and it found that the requirement that the person gathering signatures be a Virginian is unconstitutional on First and Fourth Amendment grounds. So this changes that, and what it does is it simply says that someone from outside of the state can circulate a petition, and then it contains some safeguards to make sure that that person, should there be any issue raised by anyone with respect to the signatures on petitions gathered by that person subjects him or herself to the jurisdiction of the Commonwealth, says they will honor any service to come back to the Commonwealth, and if they don't, the signatures on their petitions go away.
And that's basically an affidavit they have to affix to every one of the petitions.
Correct. That's correct.
Okay, does everybody understand the bill? Are there questions for Delegate Sullivan? Are there those in the audience who would like to speak in favor or against this bill? Okay, the bill is before the committee.
Move the report.
Okay, I've got a motion and a second to report the bill. Are there other motions, or is there any more discussion? If not, open the roll.
Nine ayes, 6 nays.
Okay, your bill is reported.
Thank you, Mr. Chairman, members of the committee.
Delegate Cole, come on up.
Thank you, Mr. Chairman, members of the committee. I have House Bill 43, and you've seen this bill before, and it deals with voting in split precincts. This past election, I continue to receive reports of people who live in, and vote in split precincts, of them going to the poll and being handed the wrong ballot. And different localities or different precincts have handled that in different ways. I received reports that some localities, when the voter brings it to their attention, they'll hand them a different ballot. Other localities will say, tough, you vote that one that we gave you or you don't vote. And what this would do is allow, if someone is in a split precinct and they think they've been given a wrong ballot, they would be given a provisional ballot of the one that the registrar thinks they should vote and the one that they think they should vote. And then they would vote them, and then afterwards the local electoral board would decide which one to count.
So they basically they vote both ways, and then, but after the fact, the electoral board can decide which one to count. The other one gets trashed.
That's correct.
Okay, does everybody understand the bill? Senator Spruill.
But you allow them to vote the way the electoral wants them to vote. But then you say, well, I'm gonna do it, but that ain't right. So you ask for a provisional ballot, so you can vote this way because they say you have to, but you can vote a provisional ballot because you think it's right.
Yeah.
There are two provisional ballots, one both ways. One the way they think, one the way the electoral board or the election official thinks that is right, and then after they investigate, the one that they found to be correct is the one they count.
Second question: would the electoral board, would they get back to the voters and say, hey, we found out exactly, let you know exactly which one you will be in, so it won't happen again?
Well, I would hope that once they check and find out which ballot is correct, that if they have it incorrect on their poll book, that they would correct that.
Okay, thank you.
Mr. Chairman.
Now, I will say in full disclosure, I received an email from the Attorney General's office which said they had problems with this bill because they said they think it's allowing people to vote twice, which I don't think it is, but because only one vote would be counted.
Only one vote will count.
As my chairman said to me a while ago, he's not a senator. He reminded me of that while ago.
He didn't have, that's what I said. He didn't have a vote.
Mr. Chairman,
Senator
not a
Reeves.
question necessarily for Delegate Cole, but just speaking to the bill if I can. This happened to me in the last election, and I know Mark knows about it. My legislative aide lives in the district, went to vote, and they told him 3 or 4 times that he couldn't vote for me. And he finally said, I'm Senator Reeves, legislative aide. I live in his district. Look it up again. They finally looked it up again, and sure enough, he was right. So I think this is a good bill. We've had multiple. Okay, I probably had at least 15 or 16 votes like that last election. I know Doug Cole went through that with between in Stafford and the city. So I think when the time comes, I'd like to make a motion.
Well,
Mr. Chair?
Senator Boyce.
I just have a question. This is only dealing with split precincts where you're going to the same polling place.
Correct.
And you might be Mr. Cole and someone else might be Mr. Cole.
Well, no, I mean, it
No?
doesn't get into the names, but it does do split precincts where you go vote, you live in a split precinct, and you're in Fredericksburg, and you think you're going to go vote for Joshua Cole, and they hand you a ballot with Mark Cole on it, and you say, hey, that's not right. I live in Joshua Cole's district. And the way it is now, they'll probably tell you, tough, you vote the one we gave you, or don't vote. And with this bill, what they would do is say, oh, okay, we'll double check. We'll give you 2 provisional ballots, one for Mark Cole and one for Josh Cole, and then you can vote them, and we'll double check and make sure we count the correct one.
Okay. Are there people in the audience who would like to speak for or against the bill? Okay, the bill is before the committee. Okay, a motion and a second to report the bill. Are there other motions or further discussion? If not, open the roll.
Fourteen ayes, 1 nay.
Okay, the bill is reported. Thank you. Okay,
Cole.
Delegate Tran,
You sound like a good Democrat.
come on up. You just have one bill?
I do.
Okay,
Thank you so much, Mr. Chair.
that might be the quota.
I hope the quota is not less than 1. I have House Bill 1210 in front of you, and I do have some amendments
Okay.
to help tighten the language a little bit.
Meg, do you have the amendments? No. Okay, we've got a series of line amendments. There are about 7 of them. Do you want to explain the amendments first, and then we'll adopt them, or we'll consider them?
Yes, sir. So sometimes in my mind, it's hard to explain the amendments without the overall context for the bill, but I'll.
Mr. Chairman, could the lawyer do it, help her out so she can move along fast? Could the lawyer mind doing it? You mind letting her do it much faster?
Okay, Meg, do you want to walk through what the report, the amendments do?
So I'll report the amendments on line 20, after materials, strike include, insert mean.
Yeah, we've got them. I just wonder what they do. Do you know?
They were requested by the patron. I thought she might be better.
Okay.
I will quickly explain. So amendments 1, 3, and 4, and 6. 1, 3, 4, and 6 are the same amendments, which rather say these materials are included in an incomplete list of things that ought to be translated. For this bill, these are the specific materials that would be translated into minority languages. And then amendments 2 and 5 limit the requirements of what a registration notice is, particular to the changes in this bill. And then amendment 7, so overall then, amendments 1 through 6 really just kind of confine the changes that we're making in this bill specific to these changes and doesn't affect other sections of the code. Line 7 makes sure that localities are required to, would distribute materials in the preferred languages of a voter and not So like, for example, if I were solely a Vietnamese-speaking voter, they wouldn't have to give me election materials in other languages. So those are the amendments.
Okay, and these apply in the covered localities, which are described in lines 35 through 40, well, 44. Is that right?
Yes, sir, and I can get into the broader context of the bill.
Okay, but the amendments look to me to be just clarifying or limiting. Do I have an motion on the amendments in a block?
Second.
Okay. Motion and a second to adopt the amendments. All in favor, say aye.
Aye.
Okay. Briefly, what's the bill do?
Briefly, the bill does two things. One, it codifies into our state code what's currently in the Voting Rights Act around providing election materials in minority languages for communities where they meet a certain population and language ability threshold. So we don't change the threshold. We adopt what's in the Voting Rights Act now, and those are essentially lines, 31 through 43.
So basically, 5% of the citizens of voting age are in a language minority, a single language minority, and are unable to speak or understand English adequately. More than 10,000 of the citizens of voting age.
Yes.
Okay, I get that.
Okay, so that's
that's all existing law, though.
That is existing law and
Okay.
federal law. The other piece that is equally important is in the lines 18 through 29, where it would require the state to provide some of these materials in a minority language only if there are localities that meet the threshold we just discussed.
So these are not materials that would have to be provided statewide, but only in the localities described in this subparagraph A of 24.2-124. Those are the only places those special language, minority language materials would have to be provided.
That was our intent, yes.
Okay. Okay, does everybody understand the bill?
Mr. Chairman.
Are there questions? Senator Reeves.
So, Delegate Tran, Fairfax County has over 160 different languages. Is there somebody that can speak to how many of these different brochures Fairfax County alone is going to have to provide?
Sure. I think Fairfax County is here, and as Ellen comes up, I just would like to say there are only 2 languages in Fairfax County amongst the many that are spoken that currently qualify, and it's Vietnamese and English. And Fairfax County also voluntarily provides materials in Korean. But I'll let Ellen speak to that.
Mr. Chairman, members of the committee, Ellen Volo on behalf of Fairfax County. We are also required to make materials in Spanish available. So currently required to provide materials in Spanish, Vietnamese, and then we're really close to hitting the threshold on Korean, and so we also provide those materials.
Mr. Chair, follow-up question?
Senator Reeves.
And is that based off the last census, or what's the current data? Is that based off registration? What is that based off?
I believe it's based off of the last census.
Okay, but the requirements in here are your understanding of what the federal law already requires you to do?
So my understanding is that it does pull language from the federal requirements,
Okay.
But yeah.
Okay. You have something else, Delegate?
I just want to, part of the reason I put this in, Mr. Chair and Senator Reeves, is that with the upcoming census also and the upcoming data that's going to be available, I do think there might be more localities that would meet these thresholds. And so this gives an opportunity for the state role in terms of some efficiencies. So for example, rather than having, if there were 2 localities that were needing to provide language materials in Spanish, for example, Fairfax and another, then the state can help with some of those efficiencies so the localities don't have to, recreate the wheel all the time.
Okay.
Mr. Chairman?
Senator Boyce.
As someone who represents one of the most diverse parts of Virginia, I'm really glad that we're putting this forward, and when it's ready, I'd like to make a motion.
Okay, are there people in the audience who would like to speak in favor or against this bill?
Mr. Chairman, members of the committee, Ellen Volo again with Fairfax County. We do support the bill. We asked the patron to incorporate some amendments, and we're thankful that she did that. Thank you.
So these amendments came from Fairfax County?
At least some of them, yes. I haven't seen all of them today.
Okay, are there others? Well, the bill is before the committee.
Second.
Okay, got a motion and a second. Are there other motions or is there other discussion? If not, open the roll, please. Okay, Delegate Tran, you met your quota.
Thank you. Very much appreciate the work of the
Okay,
committee.
Delegate Bourne. Delegate Bourne, how many bills do you have?
Just one, sir.
Okay, you might have a quota of one. At the best.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, House Bill 872 is really pretty simple. It adds to the list of exceptions the requirement that those first-time voters who register to vote by mail be allowed to vote absentee. It adds those folks who are currently confined awaiting trial or serving a sentence as a result of having been convicted of a misdemeanor. So we're not expanding those eligible to vote. We're simply saying that if you're a first-time voter and you registered by mail and you're also awaiting trial or have been convicted of a misdemeanor, you can vote absentee by mail.
Okay, I think I understand. Have we seen this bill before, Meg?
Not in my time here, no, sir.
Okay. Are there any questions for Delegate Bourne? Okay, is there anybody in the audience who would like to speak in favor or against this bill?
Move the report.
We've got somebody that needs to speak.
Mr. Chairman and Senators, Carol Nago with the League of Women Voters, and we do like to make sure that those who are incarcerated and eligible to vote have a way to get their ballot.
Thank you, ma'am. Okay, Delegate, our Senator Spruill moved to report. Do we have a second? We have a second. Got a motion and a second to report. Are there other motions or is there further discussion? If not, open the roll, please.
9 ayes, 6 nays.
Okay, Delegate Bourne, you lucked out.
Well, Mr. Chairman,
You
I
had a
thank
quota
you
of
and the
one.
committee members for their time.
Delegate Sickles.
Good afternoon.
And do you have 4 or 5 bills this time, or just?
No, but I enjoyed the committee's work today. I got to hear a lot of it. It was good, some good stuff. This is a real simple bill, and it has to do with the people who are eligible to. They register at their home address, but the voter file, the registration list that some folks have access to. Their address is shown only in a P.O. box. It's protected voter status. And there's six reasons how you can have your post office box listed on the voter file and not your street address. And one of them has to do with a person who is in fear for his or her personal safety from another person who's threatened or stalked them. And unlike the other five reasons, this one says you have to accompanied by evidence that he has filed or she has filed a complaint with the magistrate or law enforcement official against such other persons.
But you still have to sign a written statement that you're in fear for your personal safety from
Right.
another person who has threatened or stalked you.
That's right, and it's still under federal penalties, as you'll see in line 13, everything in this
Okay,
code section.
the
is-
only thing you're deleting is that it's got to be accompanied by evidence that you filed a
it's-
complaint with a magistrate, so
We
we're
just
taking.
thought this was unfair to women particularly who are threatened,
I
and
get
they
it.
have to provide a good housekeeping seal of approval.
Does
while the
everybody
other folks
understand,
don't.
or do you have questions of Delegate Sickles? Okay, are there those in the audience who would like to speak in favor or in opposition to this bill?
Mr. Chair, I just had a question probably for you since you're counsel.
Senator
or
Reeves.
counsel. So 13 through 16, I guess, if they send that letter in and they sign that letter saying they're one of those people, there's no evidence to support it, but they're just making that statement, that's under penalty of perjury? Or false testimony or false affidavit?
We have someone from the Department of Elections who'll be able to address that.
So it's part of the voter registration form, which the whole form is under penalty. So you don't really send us a letter. When you go through the voter application process, you can mark, I'm a law enforcement officer, I was a judge, etc. So that whole form in itself is under penalty.
So if you make a false statement on that form, you're in violation of the law. And that's somewhat like a perjury.
Yeah, and this is part of that form.
Okay, thank you.
Mr. Chairman,
Senator Spruill.
the post office box, so there has to be that in the district.
Post office box?
Yes.
Yeah, I'm not sure. I don't necessarily. I mean, a lot of people use post office boxes that are not in the district they live in. I mean, I know politicians who use like Mount Vernon.
I understand.
which-
I'm talking about as far as-
and their-
as far as-
Mount Vernon's not in their district.
I'm talking about as far as voting wise. I mean, I'm talking about as far as voting wise.
Yeah, well, it's a way you can contact them, but the purpose of the bill is to protect their address, which is in the district. Their street address is in the district.
So, Mr. Chairman.
Senator
So, the registrar would have the physical address, would have that address.
If you have-
Make sure they live in the district.
Oh, absolutely, yeah.
Okay, thank you
Yeah.
so much.
Mr. Chairman, move to report.
Got a motion and a second to report. Are there other motions or further discussion? If not, open the roll. You lucked out.
Am I the last person?
12 ayes, 3 nays.
Okay.
Thank you very much, appreciate you.
Mr. Chair.
Good work.
Got Joe. You've got Senate Bill 6, or House Bill 1678, is that?
That's correct, Mr. Chairman.
Okay.
Mr. Chairman, members of the committee, House Bill 1678, very good bill, very easy to explain. It's just adding 1 hour to the closing time of the polls. This bill comes to me at the urging of actually many people in the Northern Virginia region who talk about the difficulty of transportation and getting from job site to polling place time. Well, don't get me wrong. It's going to benefit people in Southampton Roads also.
Mr. Chair, the one thing I worry about is the people that come out to work the elections.
Yeah, and I understand that, and the argument that I've heard in some of the committee meetings are that in the rural parts of the state that there's a I don't want to say old, but that the elders, they're more elderly, and that presents more challenge. And I just simply say that, if the discussion was about making it start an hour later, or then that may be something that I'd be receptive to. But I just believe that as it is, that it accommodates the need to make voting accessible to those who want to vote.
Okay, I think we understand. This bill just moves back the closing time for voting from 7 o'clock to 8 o'clock.
Yes, sir.
We've got people out here who might want to speak, and if there are people that want to speak for or against the bill, I'd certainly entertain you.
Thank you, Mr. Chairman and Senators. Joanne Speeden from Orange County, and I'm representing the Virginia Electoral Board Association. The association is in favor of measures that improve voter participation and increase accessibility and ease of voting. We understand that this is the intent of this bill. However, we are concerned that unintended consequences of this bill will be counterproductive to this goal. This is because of the effect it may have on election officers. And I'm not saying this for the sake of the election officers, I'm saying it for the sake of the voter if this extra hour is the tipping point that drives election officers away. Already we have difficulty finding enough election officers to provide for smoothly working precincts. And with the new measures being enacted that create easier voting before Election Day, this extra hour is not critical. A polling place that does not have sufficient election officers will create a more difficult experience for the voter, longer lines and wait time. We feel that in this case, the plus of having the extra hour of voting, which is not crucial, is outweighed by the minus of having undermanned voting locations. And therefore, the Electoral Board Association opposes this bill. Thank you. Any questions?
Clerk Wheeler, Albemarle County, I would reiterate exactly what she said. The problem with getting election officers is critical, and they've already worked a 15-hour day and adding another. The other point that I would make is in Virginia since 2008, when we experienced incredibly long lines because of the huge turnout for that presidential election, which was great. Lots of people voted. But since that time, Virginia registrars and electoral boards have been diligent in keeping records based on information that they are transmitting, and this is national, to the Bipartisan Commission on Elections, showing that what used to be the voting trend was there was a bump for elections in the morning, a bump at noon, and then another bump in the afternoon of when voters came to vote. over the last 12 years, the afternoon post-rush hour voting has diminished to the point that there are very few people voting in the last hour, the 6 to 7 o'clock hour. More people vote in the morning and during the day. So adding an extra hour of polls being opened will not actually facilitate extra voters because they vote during the day or they vote absentee if they're commuting.
Mr. Chairman.
Okay, thank you, ma'am.
Dr. Wheeler, if I may, Mr. Chairman, I know what time I get to the polls in the morning. Can you tell me what time the electoral team gets to the polls if they haven't gone to bed the night before, getting prep and shit?
They're supposed to get there by 5 o'clock in the morning, sometimes 5:15, but it's a very long day. And I would invite all of you to come and spend a day in a polling place.
Mr. Chairman,
Senator Spruill.
I'm trying to figure out where you're from in Hampton Roads. At 7 o'clock, no, ma'am, it's not light.
It's 6. It's 6.
I'm
Starts
saying,
at
but
6.
it's not as far as, I'm not talking about the time. We have our harvest voter in the morning.
Yes.
And anywhere between 4 and closing time. So you said it's not a light turnout, it's a big turnout.
But
It's a big turnout in our area, and I can't speak for the areas, but in our area, it's a big turnout in the morning.
Yes.
From 6 to 8.
Yes.
And then in the evening from 5 to 7, it's heavy. So I don't know what you were saying about it's not heavy. It is heavy.
I was trying to address
Where we're not
throughout the
arguing.
Commonwealth.
Mr. Chair.
We don't want to argue. Senator McClellan.
Mr. Chair, I would point everyone to lines 335 and 336 of the bill, which have a reenactment clause. So we have a year to figure out how to deal with the impacts that this could have on recruiting.
And actually, Senator McClellan, when the First Lady was speaking, I was trying to talk to Meg because I had the bill as introduced. I didn't have that reenactment clause. Meg told me there was a reenactment clause, but it wasn't on the bill that I had. And I've got paper. I'm not looking at the computer. And so, but now I have it. There's a reenactment clause on this bill. So it's not like this is going to take effect this year. It's got to come back before the General Assembly.
Because of issues that were brought up by some of the same people that you've heard today, we wanted to make sure that we were doing something that first served the electorate, but at the same time did not overburden the process. So I agreed to the reenactment clause before it came out of the House because we also want to see how it measures up as it relates to our early voting activity that, through other legislation.
You're exactly right. We've got, with this early voting that's going to take effect this year, we can see dramatic changes in the way the votes turn out.
And with the reenactment clause, Mr. Chairman, I suspect that many of the concerns will be allayed.
Absolutely. So the bill is before the committee.
Mr. Chairman.
Senator Bell.
Mr. Chairman, I'd just quickly say I support the bill. I think this is a good bill. My district is a district full of commuters, and I would also take exception to the voting habits. My last election, I spent the last hour at one polling location. Out of 2,000 people who voted at that location that day, 700 were in the last hour. And these were people who were running and struggling to vote. In some cases, the doors closed and people were not able to vote after difficult commutes home. So with that, I move to report.
Okay, is there a second? Well, we've already had a time.
I'm just going to tell you that we're trying to collect statistics in our November election. Every polling place is going to take line assessments, so we know who's in line at 6, 10, 12, anyway, and it's 7, that we'll have some fact-based information.
And that's going to be really useful. Okay, we've got a motion to report. Is there a second?
Second.
Okay, we've got a motion to report and a second. Are there further motions, further discussion? If not, open the roll.
Oh, I'm sorry. I was hitting my...
11 ayes, 4 nays.
Okay, Mr. Chairman,
Thank you, Mr.
thank you very
Chairman,
much.
members of the committee.
Okay, is that the last bill? Okay. It's been real.